Hmm? Good afternoon. Apologies for the mix-up in starting. Now, my name is Venkitachalam. I'm a chartered accountant and a company secretary by way of introduction. And today I am addressing you on behalf of Bizsolindia Private Limited as a chairman. Bizsolindia is a group of professionals. We started our journey some 23 years back, and we are here today with about 40 plus professionals belonging to the professions like chartered accountants, company secretaries, lawyers, and management graduates. We are a company which specializes in all commercial matters. We provide end-to-end solutions to the companies. Concept to completion is our motto. And further information you can always find from our website. Having introduced me and my company, I will now start with the seminar. We started a series of seminars as part of our knowledge sharing exercise. The first two sessions were webinars were conducted yesterday and day before. And those who were not able to attend, and in case they are interested in watching these the proceedings, they can always access YouTube for the video recording of these two sessions. This is the third in the series, and we have another 3 more to go. Now, what we will do is, I have a short presentation to make. It is always difficult to do a presentation on a topic like law. But I would like to also say that, not being a lawyer, I do submit that whatever are your issues, specifically individual issues, to the extent possible, we will provide the information, and any specific issues we can always contact offline. After my presentation, please send your questions by in the video chat, so that I shall answer them now itself. And in case there are any issues which I am not able to answer, I shall answer them from my office tomorrow. Thus, please remember that whatever being said today, this one size doesn't fit all. The solutions have to be taken in the context that is general in nature and may or may not be applicable to you in particular. Having said that, now let me come to the subject for the day: lockdown and payment of wages. Consequent to the lockdown, there is no other subject which has caught the attention of so many people, like the necessity to make payments of wages during the lockdown period. The primary reason for that is almost every other aspect of production or sales or services are under our control. Whereas coming to engagement of labor, or for that matter, even laying them off or retrenching them, and making payment for wages are controlled by its own legal system. So to that extent, payment of wages is a thorny issue during this lockdown. Now I'll give you some perspectives, and I will also try to give my personal opinion. You can take it for whatever it is worth. But I'm not sitting here on judgment as to what you're doing is right or wrong. That's up to you, up to the individual employers to decide. Now, in the normal course, the situation is, the validated situation is that there's no work, no pay. In the good old days, even this particular maxim itself was under suspect, and the courts have repeatedly now have held that no work, no pay is an acceptable principle today. However, that principle doesn't apply in today's situation, because no work is getting performed, so naturally no wages become payable. But you are not in a position to offer work also. Having engaged someone, and if you are not engaging him on work because of the lockdown or whatever it is, then the onus is on you. So the normal principle of no work, no pay is not specifically applicable here, because you are not offering the work despite the fact that you have engaged someone. Though it is a fact that that someone cannot come, and you are also not in a position to offer the job. So to that extent, whatever grievance you have as employers or employer representatives, it is between you and the government, and it is not between the government and the employee. So this one aspect we have to keep in mind. Otherwise, this situation would not have arisen, because the answer is very simple. People are not coming to work. You are not able to conduct your business. So no work, no pay. Period. That's not so. Having said that record straight, now let me get to my first caveat. I feel it necessary that I must make this statement because of the extraordinary situation in which we are in. The reason being, all of us are losers, whether it's an employer or an employee, even the government. And these are all things. A pandemic is something which is not in your control, in my control, or anybody else's control. So there are losses and pain and pain. So under the circumstances, if someone comes and says that, I will look after my selfish interests, and then I'm not concerned about others, would not look morally correct. So that is why I'm making this presentation. I mean every word that is specified on this. Not only me, my company stands by every single word that is uttered in this statement. Let me read it in order to reinforce what I'm trying to say. This presentation is not intended in any way to search for justifications. That's what we normally do when the companies or factories are open. Justifications to deny anyone. If a workman He says, entitled to it, he must get it. Anyone, what is due to him on moral or humanitarian consideration. This is purely an exercise in reconciling legality with legitimacy. If a person is legally entitled to it, you must get it. There has to be an agreement between legitimacy and legality, and let us look at it in a legal perspective first, and then we can know how legitimate is that argument in a moral background. So I would I will give you my take, and morally where we stand, and morally where is my position when it comes to talking about legitimacy. So this statement is very important for me because I have worked in the corporate, in the factories for donkey's years. I know what it means to be doing industrial relations, negotiations and all that. I've been doing it for such a long time. So I know the dynamics involved and the pain and the problems that arises with this. So this is in a way is a moral justification for my presentation itself. Now let's, because we had, let me take this lockdown in 3 phases. 2 phases, 1 phase is already over, the 2nd phase is now on, and the 3rd phase would start very shortly. You look at it, how our behavior have been. I don't have any empirical evidence to tell you this is the human psychology in these 3 phases. But I have my own reasons to say that, articulate this. The reason is, I get into contact with a number of people who have always have something or other to talk on the subject. In the first phase, it was humanitarian consideration. The milk of human kindness was actually overflowing because the reason was nobody really knew how critical the pandemic was and the after effects. After all, a matter of maybe 15 days or 21 days. And in the first month, it was about 25th to 31st. And you have your money in your bank account, you can make the payment. So it was okay. So you would always be very generous, humanitarian consideration over commercial consideration. And situation quickly changed when the Prime Minister announced that the lockdown is going to be extended. Now, your own existential issue, the existential issue of yours and your companies has clouded your judgment. Clouded may not be the right word to use. Slightly changed your judgment. It is humanitarian consideration also and commercial consideration also. You don't want to want your workmen or employees to suffer. But at the same time, you also want your commercial interest to be jeopardized. Now, the crisis is looking at you on your face, staring at you on your face. It is now the situation, the phase 2 situation. Now we are not quite comfortable today because we are very anxious. What's going to happen? We don't know. What's happened to me and what's happened to going to happen to my company. I am uncomfortable. And that is the phase where humanitarian consideration and the commercial consideration weighing in at the same level. Okay. And the phase 2 from 3rd May, there is every chance that things may not get back to normal. In fact, I can more or less certainly say it will never be the same good old days. Things are not going to be normal. Even if the companies and commercial establishments and factories are going to run, it's going to run. It will not be actually the number, the terminology itself has to change because it will not run. It will just limp. It has to limp back to normalcy. During this time, it is if with an uncertain future, an uncertain number of days of limping in to normalcy, your break-even point is going to be affected. Your ability to meet your obligations is going to be difficult. Your customers may or may not pay you. You're not too sure. So in this anxiety-driven time, our own idea about humanitarian considerations also undergo a subtle change. Commercial consideration or over humanitarian consideration. I hope not. But this is what, in my conversations with some people, I generally get the impression that the kind of kindness which I had seen in the earlier days are not forthcoming today. Now, because you are very anxious, because human nature is first priority for a human is self-preservation. So it is commercial considerations over humanitarian consideration. Please don't accept me on my face value. When if and when you contest that statement, I'll be the happiest man. But this is what my reading is, based on whatever interactions I've had with some of the people in the industry. Now, the lockdown payment wages, there are, I'll just say some of those, just to give you a bird's eye view of the kind of, but these are only some of the acts which are coming onto the forefront. The Disaster Management Act. This act deals with what a unified command has to, there must be a unified command which has to undertake the steps to make sure that the disaster is managed well, otherwise it will go out of control. A flood, a storm, or a pandemic, or whatever. But one thing which I tell you, while drafting this Disaster Management Act, the pandemic of this nature was probably, I'm guessing, probably was not in the mind of the lawmakers or the bureaucrats. Otherwise, there would have been a proper coding for payment of wages in the Disaster Management Act. And unfortunately, in my opinion, each one has a different take on this. Today, the Disaster Management Act itself has become a disaster when it comes to payment of wages, because the government has chosen to act beyond the Disaster Management Act itself, and is feeling a little and put itself in an embarrassing position. So this is basically an issue concerning the original drafting. Epidemics Diseases Act, and there are state legislations are there, which is basically fundamentally and almost exclusively dealing with the how to arrest the spread of diseases. If you go through the act, you will find a number of steps which are given as to how to control and whom to entrust the duty with while controlling the epidemics. Now, the other one, obvious one, is the Payment of Aegeus Act. Both the first two acts did not have this item of wages payment in their thinking, because it is both those acts, Disaster Management Act as well as the Epidemic Diseases Act, both of them are concerned with controlling certain unforeseen events, not about payment of wages. That must not happen in their mind also. The General Clauses Act, you are familiar with this. Industrial Disputes Act, because even though there is no dispute now, there's a spelling mistake here on disputes, apology for that. The Industrial Disputes Act even though there is no dispute, so there are certain sections which become applicable here. Shops and Establishments Act, because it is similar to the Industrial Disputes Act, some of the sections will become applicable. And naturally, whenever you think of diseases, disasters, and the kind, the first thing which will come to your mind is insurance. What's about the personal insurance? What about the state's insurance? And suddenly you remember that there is an insurance act which takes care of the welfare of the employees. There are two reasons what this comes to my mind. One reason I'll explain to you a little later. The first reason is I personally feel that this now that okay, after the fact everybody is a wise person, including me. These kind of eventualities also, for a fraction of a premium, should get covered by the Employees State Insurance Act. In fact, there is an argument for invoking the provisions of Employee State Insurance Act, which I will deal with subsequently. Okay, now let us get into there is no effort now to convert everybody into a lawyer, because as it is, we have got too many WhatsApp scientists, WhatsApp doctors, and WhatsApp prophets, and WhatsApp astrologers. Now we don't want to add one more. Similar to WhatsApp lawyers. We don't want to make a pseudo lawyers in this case, but then when either you are an affected person or you have somebody to answer to. So under these circumstances, even if you are not a lawyer, you have got to understand the basic things. You may not know the nuances of the legal provisions, but you must understand basically where is this coming from. Now, the entire discussion became an explosive situation, led to an explosive situation when the government came out with this was done by the Ministry of Home Affairs, came out with an order saying that the lockdown wages must be paid to the workmen, and that no deduction should be made for the days when they don't come. As far as the intentions go, very novel, very noble. Novel may not be very noble intention. But do you have the authority under the Act to do this? Let's look at the government's own position vis-a-vis with the payment of the necessity to demand payment of wages by the employers. Section 10(2)(L), that is not 1 or I, it is L, small l. Because this is a provision under which the government has invoked the power to ask the private industry also not to deduct wages for the number of days the workman or the employee doesn't come to work. Lay down, what does it say? The provision says, from where they have taken the authority which is quoted in that order, lay down guidelines for or give directions to the concerned ministries or departments of the Government of India, the state governments and the state authorities regarding measures to be taken by them in response to any threatening disaster situation or disaster. Disaster situation or disaster. Now look at it. This is basically on the management of the disaster, which is nothing whatsoever with these kind of ancillary periphery issues. This is, and the objective of because this gets supported by the objective of the Act says, an act to provide for the effective management of disasters and for matters connected therewith or incidental thereto. It is incidental thereto. If they had mentioned that in the drafting itself, one more clause which says that during the subsistence of a disastrous situation, wages have to be paid to the workmen. This the entire discussion would not have taken place. Uh, Now there is also one more provision which is there, Section 72 of the Disaster Management Act. Management Act. The the provisions of this act, there are I can see some hands going up, but I shall answer your queries at the end of this session. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith, contained in any other law, for the time being in force, or in any instrument having effect by virtue of any law other than this act. Quite a complex construction of sentence. Basically, what it says, Section 72 of the Disaster Management Act says that it virtually supersedes all other provisions in all other acts in the country. It has got supremacy. The provisions in the act has got supremacy over the provisions in other acts, provided you have a similar provision in the other acts. Suppose, let us assume a situation where payment of wages, provisions regarding payment of wages is already available in the Payment of Aegeus Act. Suppose a similar provision is similar or a different, let's assume that a different provision is there in the Disaster Management Act. There is a conflict between two acts, provisions between two acts. Under the circumstances, Section 72 would come to the rescue of the Disaster Management Act and the Ministry of Home Affairs to say that, okay, this provision is superior to the other act because it has already been given that provision and the status in the act itself. As long as the similar kind of provisions are not there in this act, this to assume, arrogate to oneself the right to promulgate any order does not will not survive legal scrutiny. This is the legal provision as far as the Disaster Management Act. So my own take on this particular thing is, government on its part wanted to show a picture that, though there is a problem, though they are acutely aware of the fact that, there's going to be a considerable amount of suffering on the part of the labor class and those people who are the urban poor, something needs to be done. And this is more in the nature of some kind of a wishful thinking and an advisory coming out of some kind of a wishful thinking, because the Disaster Management Act does not give the government the authority to ask me to pay wages to my employees. If at all I have an employee gets paid, I have to do it on my own, but not under the Disaster Management Act. Now go to the next, the other this one of Epidemics Act. What is the object? I'll come first to the object. Prevent the spread of epidemic diseases. This is basically the objective of this act. And how do they do it? One is the objective, the other one is the process. This is the objective of the act, and what is the process? This is how they go about, Section 2 particularly. This is the substantive part of the act, to take such measures and by public notice prescribe such a temporary regulation to be observed by the public or by any person or class of persons as it shall be necessary to prevent the outbreak outbreak is a, I see another word for your pandemic in this case, outbreak of such diseases or the spread thereof, and may determine in what manner and by whom by whom any expenses incurred, including compensation if any, shall be defrayed. Multiple readings by me, I could not find the reason to assume that this will have some influence or some kind of precedence or over the Payment of Wages Act as far as the money to be paid to the workmen or the employees. So Epidemics Act do not come to the rescue of the employees who unfortunately happen to suffer the rough end of the stick. Now the Industrial Disputes Act. Now when you do, this is one act, though it pertains to the Disputes Act, there is one particular, the natural calamity is covered in this. So even though it is dealing with disputes, now this act gives some succor to the people for a temporary period of 45 days, so that a person can be laid off and make payments to him as per this. What are the conditions on which you can do that? Layoff means a failure, refusal. Okay, these are all the things which that's in the normal course. Shortage of coal, power, raw materials, or the accumulation of stock or breakdown of machinery, or natural calamity, or for any other connected reason, natural calamity or for any other connected reason, to give employment to the workman whose name is there on the muster. This is very clear that if in case of a layoff, if there is a natural calamity, you can lay them off. But you must pay 50% of the wages, and for a period of 45 days. That 50% comes in section 25C of the Industrial Dispute Act. He shall be paid by the employer for all days during which he is so laid off, except for such weekly holidays as may intervene, compensation which shall be equal to 50% of the total basic wages and DNS allowance that would have been payable to him had he not been so laid off. That means you pay 50% of the wages and you can lay them off. In fact, government does not want even that to happen. Because I'm not questioning the intention of the government, but I'm only questioning the legality of the legitimacy. I'm not questioning, but then we'll have to reconcile between the legality and the legitimacy. It is legitimate because the poor guy, he is going to suffer much more than you and me. So the legitimacy is not in question, but the legality is in question. But how to marry these two is something, it's an issue which we will have to decide ourselves as we go on. Now comes this issue. There was a video I had seen where somebody, I forgot who had taken it. It's a Supreme Court lawyer, a brilliant lawyer, by the way. He said that you have this Employee Insurance Act will come to help the workman or the employee, and he has given the justification that Section 46 say that he says that this is an employment injury. There is a definition called an employment injury, and that says I'm writing Section 2(8). That means a personal injury to an employee caused by accident or an occupational disease arising out of and in the course of his employment, right? And periodical, if that employment injury happens, he says, periodical payments to an insured person suffering from a disablement as a result of an employment injury sustained as an employee under this act and certified to be eligible for such payments by an authority. Okay. So basically, it's an, if you sustain employment injury, what is this employment injury? Employment injury means a personal injury to an employee caused by accident. I pause. Or an occupational disease arising out of and in the course of his employment. How do you read this section? The whole issue is how do you read it? Nothing to do with the language, but of course everything to do with the construction. And how do you read this section? Employment injury means a personal injury to an employee caused by accident. That means tomorrow this man, your employee meets with an accident at home, the ESI will have to take care of him. If there is an accident outside, ESI will have to take care of him. And ESI will have to take care of him whenever there is an occupational disease. That occupational disease, that is the diseases which occur because of this job, arising out of and in the course of his employment. Because of his employment, and if some disease happens, he should be taken care of. Is that the correct way of looking at it? I am not too sure. Even though the lawyer was brilliant in his argument, he says these two have to be, these two sentences have to be separated. These two parts of the sentences have to be separated and read into. Employment injury means personal injury to an employee caused by accident. And employment injury, that's not or, now I'm saying, and an employment injury means a personal injury caused to an employee caused by occupational disease arising out of and in the course of his employment. What he's trying to say is that the arising out of and in the course of his employment has to be, this is different, and the first part is different. Accident, up to accident is one part. So any accident happening, and this is an accident happening, and he is an employee, and he is not able to attend office, so it is an employment injury. And because of that, because employment injury is covered by the ESI, the ESI has to reimburse. And he has also given statistics that the amount of money which is lying in the fund of the ESI invested in the banks, so it can take care of the requirements. But unfortunate part is the employment injury, if the accident has to be considered, the ESI would always today would be flooded with accident claim, because it becomes any other general insurance company. So accident, any accident, any life insurance, general insurance, whatever, because of accident. Well, there is no difference between an insurance company and employee insurance company. So this is the basic problem with this argument. I don't think it will stand legal scrutiny, and that is the reason that I don't accept this as I don't accept it that this will be accepted by the courts of law. So this has to be seen that accident also, this has to be read as employment injury means a personal injury to an employee caused by accident arising out of and in the course of his employment. So these two have to be seen together. I will give you an example of this, just to an aside, not a serious example. Hang him, not leave him. Now, if most of you, if you are like me, my reading of this, this is a verdict given by a judge. He has not given a speaking judgment, speaking order, and he has given a verdict: hang him, not leave him. This is a very famous example which goes around. Now, if you are like me, your take would be that, okay, this man has committed a murder and he has to be punished. This is what I take it from here. So which let me I make a slight change and then rewrite the whole thing, right? Hang him, not leave him, because he has to be punished. The judge has found him guilty of murder, and he has to be punished. Yeah, absolutely. Now, you are with me. I assume that he has committed a crime and should not be left. Now you shift the semicolon. Hang him not. Leave him. The sentence is the same. The semicolon has made all the differences. This is only to bring home uh, the nuances of reading this particular clause. So my submission to this is that this line of argument may not be acceptable to the. Of course, it will not be acceptable to the ESI, and also it may not stand legal scrutiny. All right. Now back to serious. Now let us come to what should we do. I think this is a substantive part of my point. Now, there is no free lunch. Even the employee knows. This, now, there may be companies, there may be organizations where you must already be demanding performance, and you already must be getting performance up to the expected standards. If that be so, this first point is not for you. If it is not, in general in India, the productivity efficiency levels are so poor that this is not really true. So I have my own take this is there has to be a relentless and ruthless exercise in demanding performance for employees, because today it's a matter of survival. It's not only a question of survival of his survival. Forget about me. It's not if he's my employee, but the unit has to survive. So to that extent, if we are going to do something for them, we also need something in return. So demand performance from every employee without compromise. I can't tell you to do. I can't tell you something like ask him to work for more hours. That may be a recommendation which may be against the spirit of law. But if required for the survival of the organization, that may have to be done. We are living in difficult times, and the difficulties are not going to spare anyone, the employer as well as the employee. Get the employees on board. Now, all the time we have had confrontation, no comfortable negotiations. Even our wage negotiations are an exercise in confrontation. Look, whether it is an employee or employer, we are looking at death at our doorstep. So this, I think, would change our attitude. In fact, in my day before yesterday, also in my presentation, I had this point. Things are different outside, and things are going to be different from inside for me also. Because for the first time, I realized the vulnerabilities of my own existence. Mera company ka chodo. My own existence. So is the case, the employees' existential anxieties are going to be much more. So it is likely that even the most cantankerous workmen would also be willing and wanting to be taken on board with you to help you overcome the situation, you'll always say that, okay, then another day will come when we can confront. Today, let us cooperate. I am betting on this particular thing, though it may sound a little, uh, it sound like sloganeering. But I do believe that this is likely to happen based on my years and years of donkey's years of experience in dealing with labor. Then the third point, take employee engagement activities to the next level. Because today, my employee activities is more done in the conference rooms and more done as the HR to show their performance, improve their own performance matter. It's more as a ritual. Now today I'm telling you this much because we have also in our company also we are also have got certain amount of activities we have taken as part of our commitment to the employees, that we want to reach out to the employees and put them at ease. Now today we are not in that kind of a situation that because I want an increase in wages and because of that I am in a negotiation, so then I have to confront and then I have to demand and I have to agitate and I have to go on strike. No, nothing, none of the same. Today he understands that his own existence is in peril. Please understand the fact that many of you must be employees also. Understand the fact that your anxiety levels are much more than that of an employer. Employer has got his anxiety, but probably I am saying is that he may not die overnight, whereas you will die of debt overnight. So this is something with the employee engagement activities to a next level, so that we go out of the way to recruit loyalty to ourselves during this time. It's not as if let us not be consumed only by the fact that wages to be paid or not to be paid. There are much bigger things which have to be done. I mean, yeah, it is possible that you may be assuming that I'm talking like a preacher in a white gown and talking from a pulpit. But I do believe this, and I do believe this, and I do believe that I have the necessary authority to say that, having dealt with thousands and thousands of labor-related issues, strikes, lockouts, the works. So this is something which I will very strongly recommend, even if it sounds like a preacher's sentence. Do not employee cost to escalate as with any other cost. Now, you can't afford to have any escalation in cost. Now, today, it's a question of survival. An employee may not, from his immediate anxiety point of view, he may not see that way that, मेरे को इतना पैसा चाहिए, मेरे को EMI, I have to pay my EMI. So that, but then you are not in a position, unless of course you are one of those lucky few whose cash balance is very good. If that is the case, you are not just lucky, you're extraordinarily lucky in today's circumstances, because today cash is king. And today, if you have that kind of a position, also be careful not to splurge, because we don't know what the future holds for us. On 3rd of May, there is no guarantee that we are going to step out into the Garden of Eden. We are not going to step into a place where the things are going to be the same all over again. No, we are going to get into a much bigger anxiety, going to get much bigger anxiety neurosis, because till such time vaccine is found, we are susceptible to the virus. It is not going to go away anytime soon. It may take, the vaccine may take about a year, 1.5 years. this morning I saw that somebody saying it will take 3 years, but somebody was saying it will be 6 months. One really doesn't know. But the problem is now you're going to operate at 50% capacity, perhaps maybe 25% capacity. The asset is all these are going to contribute to your cost because of the fact that your fixed cost is already there. You can't reduce it. You can only fiddle with some of the variable costs and a very minuscule part of your fixed cost. But your success will depend on making that minuscule part a little larger. So to that extent, keep a hawk's eye on the employee cost. Because I'm not saying, again, I'm not saying that sack the employees, reduce their wages. No, get extra productivity from them. You don't allow that temptation that you sack the employees. After all, kya hone wala hai? I can't afford. That's fine. That's a moral justification. If you can look at the mirror and you feel justified, go ahead and do it. But then if you can't and your conscience is going to break, then there are better ways of doing it. See, today in this particular situation, no judge, no priest is going to come and tell you you have done something wrong. You are yourself going to, you have to be accountable to yourself. This is basically my, I'm talking like a preacher. Now, if some verticals, now this has got a slight legal implications also. If some verticals within the company are generating cash, you may still able to pay. And if you are able to pay. The reason is that one day, tomorrow, if suppose, I don't think the chance that the Disaster Management Act will be upheld. The act taken, the order taken out by under the act will be ratified by the court. I don't think so. But if they do, then if you're not paid wages, and your justification becomes very flimsy. If you say some part of the company, verticals. I'm not saying that two different companies in the same group. I'm not saying that. Say some verticals within the same company try to pay. I'm not saying that you may not be able to pay the whole amount or part of the amount. That's up to you. Each individual is unto himself. So if the vertical is generating money and you're not paying, the court may also think that okay, the company could have paid the money but then did not pay, provided that disaster management order stands. Okay, that's one big if. Now, encourage employees to exhaust their. Now comes to the other nuts and bolts of our tradition. So what we can do is that okay, now ask the employees. You exhaust your leave and continue. We'll later, in case you have to. First of all, now that nobody is going to travel in the foreseeable future, even from here to Mumbai or here to Pune or here to Malegaon, it's very, very no holidays for the next couple of minutes. And the reason is also that you have had a forced holiday already, one, and you don't have the money to afford a holiday, two, and third, this one is you can't travel without with the comfort that the man sitting next to you is not a carrier. So if the travel is something, even if you want to, you may not be able to do it. So then, one way of doing it, to ask people to go on leave, one, so that he doesn't lose money, and then the company also has got given a reasonable solution to his monetary problem. And there might be people who don't have leave. Ask them to take leave without pay. But then, if the layoff become necessary, don't lay them off. Let them go on leave without pay, and continue them in the service. Now, this is one part of it. The other part of it is there are some employees who are working in the so there are essential services people are working, they have to be paid, and there are those who are services sector, particularly those who are working from home, they have to be paid, and the others who need not be there during this time, and we are also not in a position to make payments to them. Let them take a leave without pay if they don't have a leave, and continue their service. So why I'm saying is that come 3rd May, not on 3rd May, come after 3rd May, there'll be a lot of people who will be floating around in the system, looking for employment, because the employment market is going to be suppressed quite a bit. People will be willing to accept any kind of salary to take up another job, because some of the people, not everybody will have the same ethical standards. Some may ask people to go, some may retain them, some may give some odd jobs. All kinds of things are going to happen, and it's not going to happen not only for 1 day, 2 day. And if you believe me, it will take quite a while, and next 1 year we are going to see in this kind of a flux. If that is going to be the case, if the person, I mean, whom do you want, and then you don't want, I'm assuming that you don't want him to go, but at the same time, you can't afford him. And if that is the case, let him go on leave without pay. If there is no leave available to him, let him go without pay. But then please remember, in some of the state governments have already taken out notifications or orders, whatever it is, which very specifically says that even if the person during this time, lockdown period, even if the person goes on leave, he will be treated as on duty, not on leave, and will be eligible for the normal salary. It is, again, there is a kind of a iffy kind of a provision, but then I'm taken out under the same suspicious provision. So, but at the same time, keep in mind, so you don't ask, don't give a circular saying that, no, please ask for leave, I'll give you. Let the leave application come and you will accept it. So this is my way of this one, that, but at the same time, you have to get the employee on board, and then the employee should say that, why you're doing, you're actually going out of the way to make sure that, to buy the employee loyalty. Okay, no, this is again, convert is a calamity to an opportunity to win employee trust and confidence. Generally across the board in India, if somebody comes and tells me that, the trust levels between the employer and the employee are so high, and then we don't have any problem, I would take it to the bucket full of salt, because that's not the normal conditions what at least I'm used to, because despite the fact that, I've been in this field for such a long time, I don't think that is an honest statement. But today there may be a time when both of us are fighting the same enemy, that too invisible enemy, and both of us are going through the same anxiety. Probably a new relationship might get developed. Why might? Would get developed. I am betting my last rupee on that. But in the end, the day, end of the day, it's all about you and your moral compass. Now today, if you can, my point is that, even if I succeed, if I or your lawyer succeeds in getting an order saying that, wages need not be paid by the employers, fine. For heaven's sake, don't celebrate, because you're celebrating the agony of another human being who is much worse than you are. So I would be doubly circumspect, even if I get an order which says that I don't have to pay, but pay I must to satisfy my own conscience. Well, that is something which you will have to decide, which I have to decide myself, and I have to say that tomorrow it could be one of you or maybe many of us, maybe in a position that we are ourselves bankrupt already, because we have come here. You look at it. Before we came here, where were we? We are already in a slowdown for the last 2 or 3 years, and there is nothing in the kitty. Nothing is available. So under the circumstances, it may not even be possible for you to make the payment. But that is my stand only you can take, and that is a position only you can take. But when you take a decision of this, look at uh, the humanitarian aspect of your decision. This is not a pure legal decision. That's all I have to say. Now I will go to now. Now let me. Now all eyes are turned on this particular case, which is now before the Supreme Court awaiting judgment. See, the Nagarika Exports Limited has already gone to the Supreme Court. Many of you must have already seen, because there's a public interest litigation has been filed from a Mumbai-based company, which has gone against, against the government of Maharashtra and the government of India. And the reason which he has given are more or less what I have given, except for one, or almost all the reasons. I'll just read out one by one, which, to my mind, because to my mind is logical. The central and state governments have no power to issue directions to a private establishment to pay wages under DMA, that is Disaster Management Act. The reasons I have told you. It is beyond the purview of the Disaster Management Act. This is the first ground they have taken. It is beyond the purview of the Act. Now, second, this one is, you and I know this, it's a matter of fact, impossibility for the establishment to pay on account of lockdown and the consequences, because there is no money. When there is no money, how do I pay? This is the second one. This is a natural thing, as natural corollary to the lockdown. Now, government directions are unreasonable when the unit is closed. Now, you are coming and asking me to make the payment. Where will I go for money? My customers are not paying me. My suppliers are demanding. You are demanding. And my capital has already got eroded during this slowdown. If I have to, even if I have to make the payment, I have to generate cash by reopening the unit. It's not possible. So this is the third ground they have taken. Okay. The government directions violate Article 14 and 19 of the Constitution. These two articles are the one Article 14 is about. I'm no expert on this constitutional matter, nor do I claim that I'm an expert on others. But I am not an expert on the constitutional matter. Article 14 talk about equality before law. Now you're saying that you survive. The class of employees will survive, but a class of employers should die. That's not equality before law. So this is one argument is being taken, and this, Article 19 of the Constitution is about the freedom to pursue the profession. Number of freedoms given. Out of one of them is to pursue your own profession, trade or commerce or whatever it is, subject to only to certain restriction. Only certain restrictions can be imposed on the people, on the employer, on the when you are pursuing your profession. So this it violates Article 14 and 19 of the Constitution as per the are the grounds taken in the Nagrika Exports Limited before the Supreme Court. And the third one is, if you can pronounce this, I think you would have won. I think you would. I would assume that you are winning the case. Lex non cogit ad impossibila. Impossible to comply with the provisions of the statute. Now you are asking me to. You say that jump from the fourth floor of of your factory if you want some subsidy. Is something which you cannot do. This is an impossible act to comply. If this is an impossible act to comply, this gives you a justification for not paying wages. There is a precedent. I forgot the name of this one. It is there in the case papers of this case. Also carries the previous judgment given by the Supreme Court itself. I think in 1976. It's an impossibility. Now today you are asking me to do an impossible act. What do I do? I can't. So that becomes an excuse for you not to pay. Excuse is not the right word, I suppose. Though it is, that is the word they have used. It is not an excuse. It's a reasonable and real situation. Right. This I have to know because this judgment could come any day. By the way, this afternoon, one judgment has come from the Supreme Court, which talks about the payment to the migrants. And the details, I still have not seen the details. Payment to the payment of wages to the minimum wages to the migrants. And there, in that case, the Supreme Court has just said, no, we don't want to get into the area of finance and the policy of the government. So here they have stayed away. But this decision has not come. If this decision comes, this will answer all your queries except your moral stand. This will clear that matter. So let us wait for the judgment, which could be any day. Now, this is one thing which my partner Manoj has shared with me this morning. So this, there seems to be a kind of mellowing of the attitude on the part of the government. This says that the corporate affairs, Ministry of Corporate Affairs say salary, payment of salary is a moral obligation. If it is a moral obligation, why did you make such a hoo-ha about the whole thing? Now, is it okay? If the government is right from where they stand, but the moment when you ask me, when you order me to make the payment, I react. When you say that you make the payment on the basis of moral obligations, I am a different person. But when you say that you order me that you make the payment, then I say no, why the hell I should pay? Now that means the grace is taken out of that decision. But then this seems to be, this is an indicative thing in my mind. This article has come, and this article says that the Ministry of Corporate Affairs says that it is more a moral obligation than if it is a moral obligation. Oh, so be it. I am also saying that it is a. I'm not even saying that a moral obligation. Yeah, I'm saying that it is a moral obligation. That's my stand. But by the way, incidentally, there is also one sentence which is of some consequences to us. The MCA also clarified that payment made to employees or casual workers during their lockdown will not qualify for CSR expenditure, but ex gratia paid over and above salary will qualify for CSR. That's a dream. But then this is a fact, but then this clarification is important for us. Okay, now that it brings me to the close of my presentation. I'm closing that presentation on the note that probably the decision. I mean, now the government feels that this there will be no compulsion to make the payment, or maybe that the chances are that we are not going to. They are not going to win the case. Okay, now The next in line for our session is force majeure, when and where it becomes applicable. That is going to be done by my colleague, Advocate Kiran Savle, from Bizsol. And in fact, this force majeure is the one which I mentioned just now, because it's an impossibility to perform an act. Is the force majeure. So that is a frustration in getting something done. That act is getting frustrated because of the factor of impossibility. So this is something which is not only in this case. There are a number of areas. Now suddenly because this particular clause has become important, because we don't know. I mean, we have seen this, because we can't pronounce this. We normally ignore this. And but now today it has come to bite us. So let us understand what it is, and who else than an advocate to give you an insight into this clause. Tomorrow at the same time, 4 p.m. at the same place, your house, or your I hope none of you in the office. You can listen to Advocate Kiran Savle talking about this. Kiran will take you through the force majeure clause applicability in a number of instances. Don't miss it. Okay. Now I will take now I'll take your questions before I go to. Okay, fine. This is the last slide. I would like to find out the legal implications of leave without pay. Considering the current economic environment, can this be done for 3 months for full-time employees? I don't find any reason why it cannot be done. Leave without pay, the very word leave is asking for permission. Now, you are not going to, if you are going to say that, no, please go on leave, that's a different matter. You are going to, somebody is asking you, I would like to go on leave for 3 months. Allow him to go on leave for 3 months. So leave for 3 months for a period of 3 months is okay according to me. We are an essential service. Employee is not coming after writing them to join. Then also them to join. Then also only a few employees join. What will be the situation in circumstances? This is from Vijay Gandhi. Vijay, the employee is not coming is because he can, probably because he cannot come, or probably he's scared, probably because he doesn't want to expose himself. But if you, on a theoretical basis, if you ask me, of course you can proceed against him, and you could even say that abandonment of service. But then during this time, would you like to do that? If I were you, I would rather get in touch with him, find out what is bugging him as to why he is not coming, or whether he is going to abandon genuinely abandon his service. That would be my stand. The opening caveat is very succinct. Laudable, sir. Subramaniam Raman. Oh, thank you, Subramaniam. Rarely do I get a compliment, so thank you so much. So we are an ITES company. We have offered the staff the option to work from home, but still 15% employees didn't respond to make the effort to do work from home. Are we legally bound to pay wages to these 15% lockdown? Now, this is in some states, yes, but then not as per the Disaster Management Act or as per the order. But people who don't come, I mean, they can't even, as per the state circulars, they are not to be treated as on leave, they are treated to be on duty. But then, this is something which, as a matter of protocol and discipline, somehow it doesn't gel with me. If they are not coming, they must be exposing themselves to some kind of action, if not today, but tomorrow. So this is something which is, to my mind, if I were in your position, Anurag, I'm not comfortable with. Sanjay Lalit, can you please share cell number in email ID? I would further consultation. Shailaja would send you the my details to you. You can always contact any of us at any time. You're welcome. Shailaja will give you the details from the office. Sanjay, again, please inform, is any law to withhold salary and wages in small firms and unorganized sector? The Payment of Aegeus Act is the same, and that they have given that the small firm, I assume that you are covered by the Payment of Aegeus Act. So to that extent, the Act applies the same way to all of us. Sanjay, please inform, he's saying, okay. Now, instead of acts, we understand what we exactly, Sheetal, instead of acts, we understand what exactly we need to do. After the acts, this has come at 4:35. I think after that I have come into what we can do and what we may do. I think I have answered it during the second part of my presentation. Atul Joshi, how to calculate the salary about work from home employees? See, the salary will be the same unless and until you can distinguish between the effort involved in working in office and working from home. If you are able to distinguish and it is acceptable to the employee, yes, you are welcome. You can make the changes. But then, do you want to do it? That's a question. But then, try, if there is not enough work, he can go on leave during that time. But then if he is working, he has to be paid. We are discussing about accident and disability and diseases. Sheetal Nahar, I thought I had spent a little more than normal time on that ESI provision. I have answered that query. If there is anything specific, you can still mail me. I'll reiterate whatever I have said. What can't you talk to the point about? Why can't you talk to the point about lockdown? No, you mean the lockdown? It is only about the payment of wages. About the lockdown, I had a 2-hour session day before yesterday. I don't know whether you were part of the session, but day before yesterday, 2 hours I had talked about lockdown, the economic implications, and yesterday for 2 hours, my partner Ashok Nawal spoke in detail about what is to be done about the lockdown and the consequences. And this particular presentation was only limited to the payment of wages because we received a number of questions on that. Mahendra Savdikar. In case of industries defined as essential by the government notification and which have been allowed to operate by the authorities, if the employees refuse to attend, citing fear of the disease, parental spouse pressure, for any other personal reason, what are the options? There are no options because that it's a matter of discipline. You've got to come, you've got to come. And then, of course, you have to make the necessary, you have to take the necessary precautions. And as long as you do it, you can insist on him is coming. Can the employee refuse to attend? And in the case, is the company obligated to make a payment? No. If you have made a conducive environment, then he is supposed to attend, and and if he doesn't, you can take action. Okay, Sheetal does not seem to have been impressed by my presentation. It's complete wastage of time and very boring presentation. Okay, Sheetal, I'll try to improve the next time, and I would love if you have any suggestions to make. I look forward to it. Mahendra Savdikar. Similarly, if the employee has traveled over to Pune in violation of the lockdown, and he is now not able to return to Pune to attend his work, what are the obligations of the company? Similarly, if the employee has traveled to, I assume that he has traveled to Pune on your advice, and he is not able to, in violation of, no, sorry, I have not read it. Similarly, the employee has traveled to Pune in violation of the lockdown and is now now return to Pune. No, then you have a wrong stand that you don't have to make the payment. You don't have that. So because you can't see, you can't be pardoning a mistake which is illegality also. So to that extent, you need not. From me to all panelists, Jamal Khan, from an employee's perspective, if he decides to pay the wages salary to its staff workers during the lockdown with a certain fixed reduction from the gross salary wages, say 25%, one whose salary is rupees 100 will get only 75 on account of the aforesaid deduction. Then please reply on the following. Is employer allowed to make such kind of deduction on account of loss of business during lockdown? Now, as on today, the government's position is that if you go by that order under the Disaster Management Act, you are supposed to make the payment. Once the Supreme Court judgment comes about whether that stand is correct or not, you will be able to take a decision on this. And you can't, on loss of business, on account of loss of business, you can even close it and you lay them off. That is permissible. In the process of such reduction, if the minimum wages of a particular worker gets reduced and becomes lesser than the minimum wages, will it be allowed? So, because this will depend on the stand which we take after the Supreme Court judgment. Similarly, in the process of reduction, if a particular employee's salary gets reduced and become liable for ESI or PF payment, in such scenario, are we liable to comply with the ESI and PS compliances for the time being? As matters stand today, yes. But is it really feasible? No. So this is we are walking on thin ice as far as this situation is concerned. Let's play along and let's see how the things unfold before we take a policy decision. Form 16, for the purpose of computing the individual tax liability from the salary income, will this deduction be allowed? As this deduction itself has to be justified, because as on today that doesn't stand justified. So the Form 16 will come much later. Jamal Khan, from me to all panelists, from the employer's perspective, if he decides to pay the same thing which I have already answered, the same question is repeated. Jamal Khan, local PF, ESIC authorities are calling us and insisting on the month payment of ESI, PF, as if nothing has happened and office is working normally. Please advise. So they are doing their job. They know what they are doing, and they also know that what they are doing is not correct. We will have to play along. And these are all extraordinary circumstances, unprecedented circumstances where you don't have an yes and no answers. But then, if it is not possible, this is like that something impossibility that that I had read about a little earlier. Okay. If he decides to pay the salary, it's the same. Jamal Khan, Sridhar Muruganandam, the Ministry of Home Affairs, Government of India, in exercise of powers under Section 10(2)(1) DMA by order number I had read out, Whereas to deal with the situation and for the effective implementation of the lockdown measures and to mitigate is punishable. It depends. I have already gone through that. The legality is suspect according to me, and if in case the Supreme Court, we will wait for the Supreme Court judgment, and we will have to take action based on that. Will the liabilities for PF, ESIC, PT, etc. will be allowed to be paid at the reduced salary on account of the lockdown? It should be possible as long as they accept the fact, the government accept the fact that it can be reduced. Now they are saying that no, it cannot be reduced. Whereas PF, they have come, the government has come forward, the central government has come forward in certain instances, the PF will be paid by the government. PFASIC authorities, this is Jamal Khan again. So authorities are for a monthly payment out there that I have already answered. Yeah, that was also answered. Then now Sridhar MC, this is already answered. Subramanian, legal and moral arguments notwithstanding, it is important to ensure people are not hungry. This is the time for the haves to ensure and provide whatever is as per their ability to ensure the above. Otherwise, there will be serious repercussions leading to chaos and disastrous consequences. Who knows? Anarchy. In these times, we must also ensure all living beings do not remain hungry. Now, as per today, this morning's assessment by some international agency, 1/3 of the world population is going to go hungry. This is something which is going to be a reality. Now, whenever I was talking about the moral dimensions in this decision, I've always have in my back of my mind that the social unrest could be a natural outcome of this virus infection. If that happens, whatever we do, there will be no, anarchy could be a byproduct of that kind of a situation. So one has to be extremely careful, and then one has to be extremely caring also. So to that extent, I would go by whatever you have said, but then it is each man unto himself. Why PF Act is not considered in the presentation? It is a social security. Now, this was not basically a. This was not that. So it was only with reference to the Disaster Management Act and the Payment of Aegeus Act to be done, and then we are not discussing the individual components of the on wages. Can we differentiate salary on field workers and work from home employees? How will you justify that? It will be. It will depend. How will you justify? How will you differentiate the salary between work from? If I'm an employee, I will definitely contest that form. That it become a kind of an arbitrary decision. Let's avoid that. According to me, and now it's the company policy will have to take precedence. Santosh Hariharan, question not there. Sajin Madhav, which are the states which have issued notification to employees on duty? Is it advisory or a mandate? Is it Maharashtra included? Yes, Maharashtra, Telangana. I've forgotten the names because you would find if needed, I will reply you on that email. Once I go through that tomorrow, I'll give you a reply on that. Please throw some light on two situations. Employee cannot do work from home due to some reason, then should we pay him? That some reason I assume that it is personal reason. If he is not attending duty, then you need not pay. But again, this caveat to remember that the government says that even if you are forced to be on leave, then you should be treated as you are on duty, not on leave. Because that some of the states have taken out the circular. As long as you are not within that state, then Sanket, this one is okay. So that part, should we pay or not? You will not be paying if that is the case. Padmaja Kulkarni decision of layoff current situation for some employees is legal and justified as client contract changed and asked for reduction in team size for some days. Decision of layoff in current situation for some employees is legal and justifying as client contract changed and asked for reduction in this one. Layoff is though something which none of us like, that is possible to be done because this is in an extraordinary situation. Yes, but it's not a question; it's a statement. So I agree. Please throw some light on two situations: contractual employees not under direct employment and direct employees who are our international workers about the payment of wages to the above. The existing situation continues as on today. There's no change. There is no change is warranted in either of these cases unless and until you take a decision that you're going to lay off or retrench or you're going to terminate the contractors' employees. But this in this condition, I mean, I don't know if it is if your financial situation is justified, then you'll have to take a call. I mean, I think I'm unable to make up my mind as to how what kind of a this one, unless and until if I have my balance sheet in front of me, I'll be able to definitely tell you, what I would do in similar circumstances. Do we need to pay the contract labor named trainees, apprentices who are present in the no, as on today? Yes. Because the government says you've got to pay, and then they have maintained status quo. Whether it is legal or not is for another day. That is precisely what we were discussing. Now, we wouldn't want to take a risk with the legal position. Very informative and balanced views. This will help us consider both the sides of the coin, moral and legality. Thanks a lot. Oh, Amar, thank you so much for your appreciation. Yes, Joshi, few of our employees have gone to their native place where there is no connectivity and infrastructure for work from home. If they would have been in a region there we have an office, we would have given them infrastructure. Are we supposed to pay them in such situation also? As of now, yes. And because I mean, this is also subject to the validity of that order. And if that this order is not valid, you can take whatever appropriate action you want to take. Can company cut down, reduce employee salary without members' consent? Jarina Syed, we will have to get talk to them, and a unilateral action will not be correct. You can't take a unilateral action in this case. Again, Sridhar, the Constitution makes it imperative for the state to secure to its citizens the rights guaranteed by the Constitution. When there is a natural calamity, the state is a guardian of the people, pari patria, yes, and obliged to provide help, assistance, and support to the victims of such natural calamities to help them to save their lives. Can the rights of the citizens and the obligations of the state can be assigned to a private establishment by way of order under the DM Act? This I don't understand. Can the rights of the citizens and the obligations of the state can be assigned to private establishments by way of an order? Is this anything to do with sprinkler issue of Kerala? I don't know. No, it's not that. No, I will study this one again, and I'll get back to you, Sridhar, because I have not been able to understand the question properly, and I don't want to end up answering it and giving you a wrong answer. Yogesh Karandikar, shall I get a payment when I was on leave before lockdown and unable to work from home, as I do not have required infrastructure with me now? So the same answer which I gave to the employer, I'm giving to the employee. yes, you are entitled to it because your leave has been sanctioned. Even otherwise, in many of the states, including Maharashtra, the leave is considered as there's no leave. I mean, that's a position which has been given under the Epidemics Act. Ravindra Gokhale. Payment of wages or salaries against the work done by the employees during month. That is employment contract between employee and employer. Then how government can ask us to pay if the employee voluntarily forgo his salary as he has not worked, then also are we supposed to pay? If employer is asked to pay on moral grounds, then we should be able to make it to CSR. Your first part of this one is correct. Those who are above 10,000 and below 10,000. Above 10,000 is basically it's an employment contract between the employer and the employee, and below 10,000 is covered by the Act, and the Act mandates you to make the payment, so you have to make the payment. Uh, if employee voluntarily forgoes his salary as he has not worked, then are we so? Because if, do you have something to say that he has forgone the salary? If that is the case, it's fine. And as far as CSR concerned, I have already read out that newspaper item where it talks about the CSR. If it is a salary paid during this time, can't be considered, and over and above the salary, if an ex gratia is paid, it can be CSR. And on moral grounds, the moral grounds are applicable to us, not to the government, maybe. I don't know. Can we say 50% salary for April as there is no revenue this month? Yes. Is it possible for you to negotiate with the employees? If it is possible, you get to an understanding and then do it. And even otherwise, the employees also would understand. Or else, you if 50% is what you want to give, you lay them off. And if it is about 10,000 rupees salary, it's basically it's not covered by the Act, then it is covered by the Contract Act. So you'll have to take into account the notice period to be given. Harnish Raja, do we need to pay the incentives which are related to production? Incentive by definition is linked to production, and the question of the question of making payment for incentive does not arise. If it is incentive is only a camouflaged payment system, then it is different. Otherwise, no. What is the validity of labor union contract which have wage hikes fixed in these times? As of today, it stands. Even if you want to revert this, you will have to go through the process and through the labor commissioner's office and with the union, with the workmen, the whole process has to be gone through. Ravi Gunani. Oh, Ravi, that's your question. Okay. Aniket Kadam. Whether payment of wages is contractual labor is binding legally on corporate. Payment of wages to contractual labor is legally binding on corporate where there is a contractual labor working. If yes, minimum wages structure also is included DA component, whether the same is also payable under the present circumstances. As of today, it is payable. That's what so if you are going to take up this issue, so many of the questions are, do we want to pay or do we don't want to pay? So see, we have got 2-3 options open. One is that honor the contract or make the payment or whatever it is, we do that, or we contest the very state that the DMA or whatever order given by the DMA is not correct, and we get into litigation. Now, while litigating, it is my personal opinion is that we stand a good chance because the way in which this is being thrust down upon us, it is untenable, and especially those units that they can prove that they can't make the payment because they are already bankrupt virtually. Vinayak Joshi, I think every establishment in private sector who they don't have government or financial assistance should maintain separate saving account naming disaster management handling fund with which the establishment should be able to take care of their employees' statutory expenses. Laudable and recommended, but then what happens is, like in economics, old tax is no tax. After some time we forget this, but then I do support how to measure work from home and pay in relation. Of course, this is something Nitin, I wouldn't be able to answer this query because it will differ in different circumstances. So I don't want to get into that. If you want to have a discussion on this separately, we can offline. We can always have it. You will have my email ID. Otherwise, the same email ID, I will come back and then reply to you. Then Padmaja Kulkarni, in some businesses, work from home facility is not available as in hotel, restaurants business as per Minimum Wages Act. Also, it is not clearly mentioned for wages payable category wise. In some cases, work from home facility is not available as in hotel and the hotel, restaurant business and all that. It's not, today it's not operating at all. So where does this come into the picture? I'm not this one. Let me read through this and then I'll come back to you. I'll reply because I'm not able to understand the gist of the question. I'm not even sure whether it's a question or a statement. Santosh Hariharan, how about job furlough? Okay, you have gone to US. What are the possibilities in going ahead? The way the westernization is going, the way we are following up these practices, one day we might see this. That's my gut level feel, because this has nothing to do with the presentation, Santosh. Sanket Dharmatikari, if employee cannot do work from home due to some reason, then we should pay. If the employee cannot do work from home due to some reason, whether we should pay this I have already replied. If there's anything you want to discuss separately, we can always discuss in unit specific. Can we pay 100% salary in part monthly installment to tide over this one? I believe yes. I believe yes. Because today we are in a kind of an unprecedented situation because survival is our priority and we have to do this. We have to do this. Morally, there's nothing wrong with this. Sunil, this is my personal take on this. Santosh Madas. Hi sir, if company take decision to deduct a 30% salary of staff for the Q1 2021, is there any legal consequences? Can company do this? If you're going to do any of these things unilaterally, somebody or other is going to come and question it. I would rather take the negotiation route. If it is not possible, and then we have to confront, and then only you confront, because that is the thrust of most of the part of my negotiation. One is morally, if it is possible; financially, if it is feasible, do it. If you can't do it, to get to the negotiation route, and then try to make it as painless as possible. Because today it is not the negotiation also is not among equal. It is actually in one way. Okay, I might put it this way: that it is a negotiation. Between equals, and a poor man negotiating with another poor man. Ours is a Om Prakash. Ours is a small manufacturing unit. Around 70 migrated laborers are idle due to lockdown. These laborers are under my subcontractor. What will be our stand? Difficult to answer this question because this number is sizable. You will be under the focus of all the government authorities and the government, the government stand of the government authorities on this. Though I do believe that they are under the they are under your subcontractor because you are giving shade, and as long as you are honoring the subcontractor's contract, there should be no problem. But then how would you be able to do that? Because you yourself must be under tremendous financial problems. So this is a kind of it has nothing to do with law, but more to do with practical realities. People who are not this one, that's a large number of people. It is quite a dicey situation. Want to discuss, we can discuss, but then is nothing to do with law on this particular point. Sridhar Vyavare, I posted viewpoints in chat. Please see if possible. I'll see. Okay, Vyavare sir. Vinayak Joshi. The amount can be contributed by company and employee with a small amount like insurance premium. Also add some part of the amount in customers to component cost. The establishment should be capable to handle such kind of a situation till at least 6 months. That's what I feel. Fine, fair enough. That was from whom? Vinayak. Okay. Uh, Virachi Mahapatra, after lockdown, in case the employee is confirmed with COVID or quarantine for certain period, do we need to pay wages? Because I think this I am not familiar, because government has taken in some of the state governments, of course I know in Kerala, some of the state governments have given clear guidance for those payment of wages regarding the quarantine period. But I'm not too sure. This is something I'm not sure. I can get back to you. That is Biranchi Patra. Okay, I'll go through this question set of questions. I'll answer this. On humanitarian ground, we should pay, but allowances such as conveyance, washing allowance, all for payment. Everything is under the humanitarian. Everything in end of the day is money. Pay money, whichever form it is, must be good enough. So whether you pay in the form of basic or conveyance or washing, but then try to make it, whatever you're doing, it's in the four corners of the law. Birachi, regards you. Thank you. Santosh, is the government order for payment of wages during lockdown applicable only to own workmen or also contractor workmen also? Can the labor contractor sue us for non-payment of lockdown wages? They will do it. They will do it because the labor, you look at the, there is a, suddenly there is a mismatch there is a disequilibrium. Now everyone is fighting for survival and fighting for some foothold in the equation. So this is something which will have to be sorted out through negotiation. When now Jitendra Bora, when Supreme Court verdict is expected, it is expected, it should be coming any day because it was done through urgent hearing. What about contract labor? I have answered this question. If the management decides to pay Mukund Bharadwaj, if the management decides to pay only 50% of the salary, can the labor department or the inspector raise objection? Then you have to lay them off. Officially lay them off and pay 50%. Then it is possible, and you have to pay for 45 days. That is possible in today's circumstances. Is Biranchi, is there any scheme from PF department for providing loan to employees for paying wages? Loan to employers, employer for paying. As of today, no. Narendra Nande, there are different heads of salary like basic and DA, different allowances like house rent, etc. In present situation, will it be legal to pay only basic and DA? On present situation, in the status quo condition, this will be treated as illegal. If that is today's government stand on this. Now, later, we can contest, we can litigate. That's all a different this one altogether. Well, that depends on your appetite for litigation. Then, in these circumstances, Nitin Dhamale, in these circumstances, can we pay advance or Diwali bonus in advance for survival of the staff? I would, if you can do that, nothing like that, because you're actually helping the employees, and certainly you'll be buying loyalty with this one gesture. Nitin, if you're going to do it, I'll remember this. It's one of those good practices. Sunil Joshi. Sunil, can we pay 100% pending salary as part monthly installment to tide over the cash flow? I suppose you can do it, though legally you are supposed to pay the refund, but then these are all extraordinary circumstances. Even if you are hauled up before the labor commissioners, still you should be able to justify, because it's a now question. You're just it's a question of survival. You are now gasping for oxygen. Sunil, if you want to try to take that route. Raghavendra Gaikwari, we at our company wish to pay all the laborers irrespective of their attentions. What about those who are officers and assistant managers? Should we have to pay the complete salary to officers, or only basics with some perks to be paid, who have not attended, irrespective of personal request, to join the duties? It was really a great session. You have given great insight. Thank you, Raghavendra. But in this one, I have an opinion. As far as workers are concerned, you're saying that you have given the money, great. And as far as those officers are concerned, you can pay them ad hoc, and then they are supposed to be there through thick and thin, and you should be you should be able to convince them that this is the best way forward. And as far as the other officers, irrespective of your personal request, have refused to join duties, I think you know where they go. They have only one way to go. Then Birachi, can we pay advance instead of salary? See, technically no. Practically, yes. The way forward is negotiate. Srinivas Patnaik, can anyone be terminated because of poor performance and the decision taken earlier? The issue is while implementing the decision, the lockdown is on. You see, on the one hand, the government is saying that irrespective of the lockdown, the payment of wages have to be made, and all that, the status quo is maintained, and there is nothing that there is no law or any other impediment in your wanting to do what you are planning to do. This is, as long as you have a good case against a person, you can always ask him to go, lockdown notwithstanding. Is stipend payable to apprentices during the lockdown? Shweta, this is no, I don't have the answer to this question. I will come back to you, because it is they are not workmen, but at the same time, if I say that okay, it need not be done, doesn't somehow sound right to me. So give me a day. I will go through all the final print, and then I'll come back to you. Sridhar, we appreciate Sridhar Vevare. We appreciate preparation and presentation, good coverage, good inputs. Thank you, Vevare sahab. You are my good friend, so you'll always appreciate. So thank you so much. But even then, good to hear from you. Thank you for coming, Sridhar. Mehul Manyar. Sir, will you please update about the Supreme Court ruling once it is out for case you discussed today? Definitely, yes. Mehul, I will definitely do it. And these questions I'm saving with me, and I'll reply as soon as I get the copy. If this Srinivas Patnaik, if this payment of wages during lockdown is applicable to casual worker who has left, migrated to other cities. See, during my presentation, I wanted to make this one point, which I skipped. See, if you know the address, which I assume that you will, because I don't think you will recruit, or even as a casual labor you take without a PAN card and the Aadhaar card and things like that. So I assume that you know it. Send the money to him, because he will need much more than the value of that money to him will be much more than the sacrifice you will make. This is one point which I wanted to make, which I skipped, because the image in my mind of this lockdown are the migrants reverse migration. This is something, is a painful thing. Do it if you can. It'll be I'll be benchmark as one of those good practices. Now I have got so many questions, and now it is already 6. Shall we? So can I take it that because the number of questions are so many, I shall individually answer all these queries. Give me 2 days time. In 48 hours, I'll answer these queries. In case even after that, if you find that I have not satisfactorily answered, you can always come back to us, give your feedback, and we will get back to you. Okay, and then this questions and the on the chats also, I have got a couple of there's a large number of chats. If I had known that if this many chats and questions are going to be there, I would have curtailed my presentation. But then even my presentation, I could not have curtailed more than that. But anyway, I will come back to you on this, because I'm sorry that I won't be able to complete all the questions for want of time, because originally I thought the session was only for an hour. That has gone up to 2 hours. So I am with great reluctance, much against my wish, I am concluding the session. My apologies to you, but then only thing is I'm logging off with a promise that I will reply all these queries, even the responses to the chats also I will give you. And I thank you for registering. Thank you for coming, and thank you for all your comments and suggestions. And we will be in touch. So with the reluctance, I am signing off. Once again, thank you. Thank you very much for being a wonderful audience. Thank you so much.